What would happen if you were injured on the job? What options do you have today that might affect how a dispute is handled in the future between you and the company? In the next few moments, this video will help introduce you to the documents currently in front of you that have been provided by your employer. You will ultimately be asked to accept or reject some key benefit options described in the documents, so please follow along as we cover this important information. Your employer is pleased to announce the company's Employee Injury Benefit Plan. The plan provides participating employees medical, wage replacement, as well as death and/or dismemberment benefits to protect participating employees and their families in the event of an on-the-job injury. If you are not already aware, the company is not a subscriber to the Texas Workers' Compensation Act, and the company's Employee Injury Benefit Plan is not workers' compensation insurance. The company's Employee Injury Benefit Plan is regulated by the United States Department of Labor and the Internal Revenue Service under the Federal Employee Retirement Income Security Act of 1974, commonly known as ERISA. Employees participating in the plan have specific legal rights under ERISA, including the right to a summary plan description describing the plan's provisions and benefits. The summary plan description you have been provided specifically sets forth your federal rights under ERISA in section Roman numeral 12. The summary plan description is just that, a summary of the official plan document that governs a participating employee's rights and/or benefits. As explained in section Roman numeral 12 of the summary plan description, you have the right under ERISA to review or copy the official plan document to obtain more detailed information. The benefits provided by the plan are somewhat different from workers' compensation benefits, and there are several different options that may or may not be included in the plan actually adopted by your employer. So please follow along closely in the summary plan description provided to you as we review the plan's benefits for participating employees who are injured on the job. This plan pays benefits to participating employees for occupational injuries received on or after the effective date on page 1 of the summary plan description provided to you. For company employees participating in the plan pays usual and customary medical expenses incurred to treat a participating employee who has been injured on the job with the company. Medical benefits under the plan terminate when the participating employee dies or when he or she reaches maximum rehabilitative capacity, which is the point when the treating physician determines that the injured participating employee's recovery will not improve substantially as the result of additional medical treatment. The concept is similar to the term maximum medical improvement that is used in the Texas workers' compensation system. Medical benefits under the plan also terminate if the participating injured employee is terminated for gross misconduct, which is a term defined by the United States Internal Revenue Code. The best example of gross misconduct that would terminate our participating employee's medical benefits would be committing a crime against the company or a fellow employee. In short, the company cannot terminate an injured employee's medical benefits by firing the employee, and the employee does not lose medical benefits by quitting the company after an on-the-job injury. Medical benefits under some plans also terminate when a certain maximum dollar limit has been reached, for example, $100,000. Other plans have no dollar limits on medical benefits. Other plans pay medical benefits up to a total benefits limit, which is the dollar amount that is the total of all benefits that the plan will pay to or for one or more participating employees as the result of one accident or series of related accidents on the job. For example, in some plans, the total benefits limit is $250,000. Other plans have total benefit limits that are defined as the total of all benefits paid to all employees for all accidents during a 12-month period. For those plans that offer two levels of benefits, basic benefits and comprehensive benefits, each level of benefits may be subject to different dollar and/or time limits, and each level may have its own total benefits limit. Be sure to check section Roman numeral 5A1 of your summary plan description to determine when medical benefits end under your employer's specific plan. There are a few medical expenses that are excluded from payment by the plan, including biofeedback, hypnosis, and acupuncture. A complete list of those exclusions is set forth in section Roman numeral 5A2 of the summary plan description that you are reviewing. Besides medical benefits for on-the-job injuries, the plan also pays participating employees wage replacement benefits, sometimes called disability benefits, during the period while the employee is totally disabled from an on-the-job injury and unable to work. The plan's disability benefits are similar in many respects to workers' compensation benefits, in that most companies have a 7-day waiting period before disability benefits begin. Check section Roman numeral 5B of your summary plan description to see what waiting period the plan uses. Similar to workers' compensation, most plans will pay participating employees who are totally disabled as the result of an on-the-job injury 70% of their pre-disability pay if the employee was making $8.50 or more per hour, and 75% if the employee was making less than $8.50 per hour. Exactly how the term pre-disability pay is calculated under the plan for participating employees paid by hourly wage, salary, and commission is explained in section Roman numeral 5B of the summary plan description. Make sure to verify how your plan handles this pay. The plan pays disability benefits to totally disabled employees participating in the plan up to a certain number of weeks. Some plans pay disability benefits for 104 weeks. Others pay for 156 weeks, and some even pay up to 401 weeks, over 7.5 years. The maximum weekly disability benefit available under workers' compensation is changed annually. The current maximum weekly disability benefit under the plan is set forth in boldface type in section Roman numeral 5B of the summary plan description. Like the plan's medical benefits, the plan's disability benefits terminate when the participating employee dies, or when he or she reaches maximum rehabilitative capacity, or if the participating injured employee is terminated for gross misconduct. Like the plan's medical benefits, the company cannot terminate an injured employee's disability benefits by firing the employee, and the employee does not lose disability benefits by quitting the company after an on-the-job injury. Also, like the medical benefits of some plans, their disability benefits are subject to a total benefits limit. And for those plans offering a choice between basic and comprehensive benefits, each level may have its own maximum number of weeks or total benefits limit for disability benefits. Please check section Roman numeral 5B of your summary plan description to see when disability benefits end under your employer's specific plan. In the event that a participating employee is killed or dismembered as the result of an on-the-job injury, the plan will protect the employee's family by paying a death benefit to the employee's beneficiary or a dismemberment benefit to the participating employee. The defined amount of the plan's maximum death benefit is set forth in boldface in section Roman numeral 5C1 of the summary plan description. For example, the plan may pay up to $5,000 as a burial benefit. If your employer's specific plan has a total benefits limit, it could apply to the death and burial benefits. If your employer's specific plan offers basic and comprehensive benefits, each level of benefits may have its own maximum death benefit and may not offer a burial benefit. Check section Roman numeral 5C1 of your summary plan description. A participating employee who sustains an occupational injury resulting in one of the losses on the schedule in section Roman numeral 5C2 of the summary plan description is eligible for a dismemberment benefit equal to the corresponding percentage of the death benefit. As one example, loss of a hand or foot would make the participating employee eligible for a dismemberment benefit equal to 50% of the death benefit. The percentages and timing of benefit payments can vary, but typically payment of both death benefits and dismemberment benefits are 20% paid as soon as administratively possible, with the remaining 80% paid over the next 3 years in 36 equal monthly payments. Payments can be accelerated under certain conditions. Other plan variations, conditions, and limitations on the plan's death and dismemberment benefits are set out in section Roman numeral 5C3 of the summary plan description. Check this section to verify the specifics of your plan. Now that you have reviewed the plan's benefits, your next question is perhaps, who is eligible to participate in the plan? As explained in section Roman numeral 2 of the summary plan description, every Texas employee of the company is eligible to participate in the plan. Company employees participating in the plan pay no premiums. There are no payroll deductions, no co-pays, and no deductibles for our participating employee to meet. The company pays the entire cost to operate the plan and to pay its benefits. Although all company employees are eligible to participate in the plan, in order to actually be a participant in the plan, you must accept the election and arbitration agreement that is attached to the summary plan description as Exhibit A. Only by signing and agreeing to the election and arbitration agreement do you become a participant in the plan and entitled under ERISA to receive the plan's benefits should you be injured or killed on the job at the company. As indicated by the 2 boxes on the last page of the election and arbitration agreement, you have a choice either to accept or reject it. Accepting the election and arbitration agreement is not a condition of your employment with the company. However, if you reject the election and arbitration agreement, you will not be a participant in the plan, and the plan will not pay you or your family any benefits should you be injured, disabled, dismembered, or killed on the job. For those of you whose employers are offering you a choice between basic benefits and comprehensive benefits, if you reject the election and arbitration agreement, you will be a participant in the plan, but will only be eligible for basic benefits. If you're not sure whether your employer's plan offers 2 levels or only 1 level of benefits, check section Roman numeral 2 of your summary plan description and the last page of your election and arbitration agreement and check to see if you have been provided a chart comparing the 2 levels of benefits. You agree to 2 things by signing the election and arbitration agreement in exchange for being protected by the plan. What are they? Under the election part of the election and arbitration agreement, you choose whether or not to participate in the plan and be eligible for its benefits if you are injured or killed on the job. In the plan with 2 levels of benefits, you choose which level you want. The second part of the election and arbitration agreement is the agreement for both you and the company to arbitrate any and all disputes between you. By signing the election and arbitration agreement and agreeing to its terms, both you and company agree not to sue each other in court. Instead, in the event of a dispute between you and the company, you both agree to use the election and arbitration agreement's procedures to resolve the dispute out of court under the Federal Arbitration Act. Under the election and arbitration agreement's arbitration procedures, when a dispute arises at the company, the employee should first use the company's regular dispute resolution procedures to try to resolve the problem. Those procedures may be in an employee handbook, or the company may simply use an informal so-called open door policy to permit employees to meet with supervisors or managers in the personnel department to attempt to resolve a dispute or problem. If a dispute is still not resolved after using the company's internal procedures, the next step under the election and arbitration agreement is to request mediation. Mediation is a settlement conference where a trained attorney or former judge tries to bring the 2 sides of a dispute to an agreeable resolution. The mediator tries to facilitate a settlement. The mediator cannot decide who wins or who loses. If mediation does not resolve the dispute, the dissatisfied party can start an arbitration. Arbitration is similar to a lawsuit in that the disputing parties submit it to a third person to decide. At the arbitration hearing, each side is given a chance to present their arguments, witnesses, and evidence, just like at a trial. The biggest difference between a lawsuit and an arbitration is that the third party deciding an arbitration is a private, neutral, paid arbitrator rather than a judge or jury. Unlike a mediator, an arbitrator renders a final and binding decision about the parties' dispute. The arbitrator will be neutral regarding your dispute. The election and arbitration agreement provides that both sides to the dispute will have equal votes in selecting the arbitrator from a list of former judges or trained attorneys specializing in employment disputes that will be provided by Dispute Solutions Incorporated, hereinafter referred to as DSI. DSI is wholly unrelated to the company. Under the election and arbitration agreement, if you have a claim against the company or one of its affiliates or employees, you will have just as much time to start an arbitration as you would to file a lawsuit. The company pays all the costs of the arbitration hearing except for $250, about what it costs to file a lawsuit and have it served in Texas. Just like in a lawsuit, you can be represented by a lawyer in an arbitration under the election and arbitration agreement. Most importantly, the arbitrator can award exactly the same kinds of relief as a judge or jury could in a lawsuit. The arbitrator can award actual damages as well as even punitive damages. If a participating employee was wrongfully terminated, an arbitrator can even award reinstatement. Although most arbitrators' decisions are absolutely final and binding, the election and arbitration agreement permits either side, or even both sides, to appeal from the arbitrator's decision to a panel of 3 different DSI arbitrators specializing in employment disputes. The 3 arbitrators would review the first arbitrator's decision for any errors, much like a Texas Court of Appeals reviews a judge or jury's decision. Because the plan is optional, you can either accept or reject participation in it. You choose whether you want to be eligible for the plan's medical, disability, dismemberment, and death benefits briefly described on this video and described in more detail in the summary plan description provided to you. Take your time and review the summary plan description carefully. If you would like, ask to watch this video again. After reviewing the information about the company's employee injury benefit plan, if you want the benefits provided by it, turn to the last page of the election and arbitration agreement, check the box to accept the terms of the agreement, sign and print your name on the bottom of the page, fill in today's date, and have the agreement signed by the supervisors or personnel department managers who played this video for you. If you don't want any of the benefits offered by the plan, check the box to reject the terms of the agreement, and then complete the rest of page 4 of the election and arbitration agreement just as described. The decision is yours. Also, if your employer's plan offers a choice between basic and comprehensive benefits, check the level of benefits you want. Once again, the decision is yours. As you make your decision whether to accept or reject participation in the plan, you may want to consider the revocation of acceptance paragraph towards the back of the election and arbitration agreement. It provides you 5 calendar days to revoke your acceptance of the election and arbitration agreement. In other words, you have 5 days to change your mind so that you can accept the election and arbitration agreement now, take home the summary plan description and attached election and arbitration agreement and review them, and be covered by the plan in the event that you are injured on the job during the next 5 calendar days. If you decide to change your acceptance and not be covered by the plan, simply follow the procedures in the revocation of acceptance paragraph towards the back of the election and arbitration agreement. Again, the decision is yours. As initially stated, your employer is pleased to review with you the company's employee injury benefit plan. After reviewing this plan, it is up to you whether or not to accept or reject this option. If necessary, ask questions or review this overview again to ensure you are comfortable with whether or not you want to accept or reject this option. And finally, if you should change your mind, you have 5 days after you accept this optional benefit plan to revoke your acceptance. You have 5 days to change your mind.